Hi everyone, Elvis Abenga here. Today, continuing with the conversations on criminal law. Today I want to introduce you to some basic principles of evidence that you need to know if you're going through any criminal trial. First and foremost, what is evidence? Evidence by itself, as defined by the Evidence Act, is the means to which a fact or an allegation is proven to either exist or not exist. For example, if I say the sky is blue, that is an allegation I'm making. How do I prove that the sky is blue? That is evidence, where evidence comes in. I can prove the sky is blue because I say I see with my senses, I perceive the blue color with my eyes, and I can call a couple of other people who also perceive with their eyes that the sky is blue, and a fact finder, who we call a judge, can then decide the sky is blue because everyone else has said they have seen the sky being blue. Now, that is what evidence is. Now, evidence generally can be split into two broad categories: direct and circumstantial evidence. Now, think about a situation in which someone is arrested and accused, for instance, of breaking and entering a house, a dwelling place. Direct evidence would be evidence of somebody, the person giving testimony, actually having perceived with either five senses: sight, smell, hearing, touch, all that, the actual act happening. So if I'm a witness and I'm saying that I actually saw this man or woman breaking and entering this house, what I am giving is called direct evidence, because I am talking of that which I have seen with my own eyes, and it deals with what we call facts in issue. A fact in issue is a fact that which, if established, leads the court to make a finding in a particular way. For example, if I'm testifying and saying, I saw him stab the woman, that's direct evidence, because if the court finds that my evidence is credible, it can act on that evidence to make a conviction of murder, for instance, or manslaughter. But then we have something else called circumstantial evidence. Circumstantial evidence based on circumstances. It is not direct in nature. It is evidence where we are not able to talk about, we never perceived, the witness never perceived or saw or heard the accused person complaining, or the accused person conducting the act, but saw other circumstances surrounding the act that could make an inference that the accused person committed the act. I'll give you an example to avoid using big language. A witness sees an accused person running out of a house carrying a knife that is with blood. That is circumstantial evidence. And maybe this is midnight. That is circumstantial evidence because the witness will not be able to say that I saw Mr. So-and-so or Miss So-and-so stab the accused, the complainant, or kill the complainant or the victim. He or she will say, I only saw him running out of the house with a knife that looked like it had blood. And so the question then would be, so why would this person be running out with a knife that is filled with blood or dripping with blood if he did not commit the crime? So that is circumstantial evidence. Some other circumstantial evidence would be maybe cameras seen, or I heard so-and-so saying him, the accused person confessing or telling another person the way he is going to commit the crime, or narrating how he committed the crime. All this is circumstantial evidence because it is not direct. You're not saying, or I'm not saying, or the witness is not saying that I saw the act happening. So that's the difference between direct and circumstantial evidence. Direct evidence hits the fact in issue right on the nail. The witness saw the act being done and testifies to it. Circumstantial evidence, the witness did not see the act happening, but saw circumstances around the act, around the time when the act was happening, that would justify the witness thinking that the act actually happened. So that's direct versus circumstantial evidence. In criminal law, an accused person cannot be convicted only based on circumstantial evidence. You need some direct evidence for a crime, for an accused person to go to jail for a crime. This is because we have what we call the burden of proof. Remember, in a previous video I said it is proof beyond reasonable doubt. And where you have evidence that is purely circumstantial, there is a lot of doubt that can be raised because of that. If I see a person running out of a house carrying a knife that is dripping with blood, how am I sure that that blood is a human being's blood? Maybe he's a butcher who's running, or some other kind of explanation that can be given. That is the reason why you can never be convicted only on circumstantial evidence. Where there's circumstantial evidence, the court also requires direct evidence, so that these two are married together for a conviction to happen. My name is Elvis Abenga from Begis Law Offices and Chambers. Wishing you a Merry Christmas and a Happy New Year, and looking forward to continuing with these conversations on criminal law and legal nuggets as we move on. Have a blessed rest of your day.